Good morning, everybody. Thank you for joining today's Get Real with Attorney Martinez. If you don't mind, please mute yourself. I'm going to let a few more people in. Okay. Good morning, everybody. Thank you for joining today's Get Real with Attorney Martinez. Today's topic is the top 5 mistakes realtors make on the FAR bar contracts. This is an informal roundtable. After the topic presentation, you will have the opportunity to ask questions about the presentation or any other questions you may have. If anyone experiences freezing during this presentation, try to take yourself off a video and see if that helps. I'm Jennifer. I'm a paralegal with Martinez Law. Next, I'd like to introduce you to Attorney Thornton.
Good morning, everyone. I'm Tiffany Thornton. I'm an associate attorney here at Martinez Law. I'm glad to see everybody virtually today, and I hope you enjoy our presentation.
All right. And now, Attorney Martinez.
All right, good morning. I'm Cristen Martinez. If this is your first time here, welcome. Thank you for joining us. I'd like to start off with apologizing for my voice. I lost my voice a few days ago. It's slowly coming back. I am chewing gum to try to make sure that my voice allows me to get through the entire presentation. So I apologize in advance for that, but by way of just brief introduction, I am the owner and founder here at Martinez Law. I founded the law firm back in 2015 as a full service real estate law firm. That's what we have specialized in from day one. That's what we continue to specialize in. And that is one big thing that sets us apart from other lawyers and law firms in the area, is that is our one focus specialty, and that's what we are experts in. So that being said, for anybody in the real estate industry, real estate agents, lenders, investors, title agents, I am here for you. I'm here to support you. I'm here to answer your legal questions. I'm here to make sure both you and your clients do not end up in court, because nobody likes going to court except lawyers. And so that is the goal of a lot of what we do here at Martinez Law. That is also the goal of these different presentations and videos that we share, is just to educate you and try to make sure that you are representing yourself and your clients in the best way possible to avoid situations that may lead to a dispute or to litigation down the line. So I'm going to go ahead and get into the topic. After the topic, we will have plenty of time for questions and answers. So your questions can be related to the topic or not. This is an open forum for us to discuss, what you've been seeing in the market, what issues or struggles you've been having. Today, our topic is the top 5 mistakes that I see realtors make on the FAR bar contract. And this is not in any way to embarrass realtors or talk down on them. Realtors have a very, very, very difficult job, a job that I could not do. And so this is to support you and make sure that you're doing everything you can to try to avoid disputes, or to set yourself and your client up so that if a dispute does arise, you're protected, your client is protected, and that dispute is hopefully resolved in your client's favor. So by mistakes, what I mean is when we file lawsuits and we defend lawsuits and we're litigating and participating in that process, what are the things that I'm seeing in the contract that is leading to those disputes that are then ending up in court? Because that's a place we don't want to be. So I'll go ahead and start. If you have questions throughout, go ahead and feel free to interrupt, feel free to put them in the chat, and I will make sure to address those. So the first mistake that I see agents make when either filling out or having their clients sign the FAR bar contract is not paying specific attention to the time for acceptance term. So an offer is made, and generally a few days, maybe a week, is given in that time for acceptance paragraph for the other party to accept and sign or to counteroffer. What happens a lot is, let's say the offer is made on October 1st and the time for acceptance is October 3rd. let's say the other party decides to accept the offer, sign the contract, but they sign it on October 4th, one day after that time for acceptance deadline. What that means legally and contractually is that we don't have a valid contract, because in order to have a valid contract, you need offer, acceptance, and consideration. So we have an offer, but that offer expired on October 3rd because that was the deadline for the other party to accept. Once that offer expires, and after that expiration date, the other party decides to sign the contract, that's not an acceptance because there is no offer on the table. That is a new offer. So if the original offeror, probably the buyer, doesn't re-sign after this new offer is made by the seller, there is no binding contract. There are some exceptions to this, like if the parties proceed with the contract and proceed to perform under it to another party's detriment. We're not going to get into all of the exceptions that can occur, but this is a very easy thing to pay attention to that can close a loophole, so to speak, for one of the parties to cancel the contract if they have a change of heart or whatever the case may be. Make sure that the last party to sign the contract signs within that time for acceptance deadline. If they do not, we need to change that time for acceptance to the appropriate date and initial, or the original party making the first offer needs to re-sign. That is mistake number one. Any questions on that from anybody? And let me make sure I have my chat up here. Okay. Mistake number two, and I get a lot of kickback from real estate agents on this one, but I'm going to say it anyway. So mistake number two that I see leads to ambiguity in the contract, which leads to disputes between parties, is using an on or before closing date. So we have a line where you can fill in the closing date, and I see a lot of parties filling in, or agents filling in, on or before October 30th, 2021. I do not advise you do that. My strong recommendation is that you put a specific closing date, October 30th. And then if both parties agree and want to close before that date, that's a simple addendum. What can happen, and what I have personally litigated in the past, is the parties may not be on the same page if we have this on or before language. So a specific example of an escrow dispute that I had that we actually litigated for about 2 years had this on or before language. The buyer really wanted to close early. So the buyer was on top of, their lender and the title company to make sure the documents were being prepared and would be ready early. The seller, and we'll just use the October 30th, 2021 date, the seller sees October 30th and is like, okay, I have until October 30th to get my stuff out of the house and prepare and make sure that I'm completely moved out. Well, what ended up happening was the buyer and the buyer's agent wasn't necessarily communicating this to the seller, but the buyer was making preparations to close early. Title company reaches out to seller and says, hey, we can close a week early. When are you willing to come in? And the seller's like, I'm not ready to close early. I still have movers coming and I need to get my things out. I can't close early. So what ended up happening was the loan package had to be redone. The closing documents had to be redone. And by the time all of those things happened, the buyer now wasn't even ready by that ending date, that October 30th closing date, and needed to request an extension, which was ultimately denied. And so this whole situation could have been avoided had there been a specific date. And then if the buyer wanted to and was able to close early, that needed to be a discussion with a separate written addendum for an earlier closing date, and there would have been no issue. So when we're doing closing dates and when we're talking about any sort of provision in a contract of any kind, you want to be as specific as possible. So a specific date is going to be better than an on or before type date, because that builds in some wiggle room that we're not sure how each party is going to be proceeding and preparing under that wiggle room language there. So that is mistake number two, using on or before for your closing date versus a specific closing date. Questions on that one? And I see a question from Bill. What if time for acceptance is left blank? So this is, let's go back to our first mistake for a moment. And I'm actually glad you asked this question because this leads me very well into my third mistake that I see. But if time for acceptance is left blank, then the offer stands open until the offeror or the buyer rescinds the offer. So it stays open indefinitely, which is not an issue so long as the buyer is intending that offer to stay open indefinitely. That could lead to issues as well, because 3 weeks later, the seller could sign and return it to the buyer, and the buyer's already moved on and maybe entered into another contract. So I don't advise leaving it blank, but if it is left blank, it means that that offer remains open until it is specifically withdrawn by the buyer. Thank you for the question, Bill. That was a good one. Okay, so my third mistake that I see realtors making in filling out the FAR/BAR contract is not checking the boxes. And what I mean by this is many contracts are signed and executed with boxes not checked, with blanks not filled out. They are incomplete, or sometimes they are filled out inaccurately. And so my takeaway for you here is do not rely on the default provisions in the contract. And by default provisions, I mean, if left blank, then 3 days applies. Do not rely on those. Check every single box that is relevant to your transaction. Fill in every single blank. And if something's not relevant, fill in inapplicable, NA. Every single provision in the contract needs to be completed in order to, again, avoid any possibility for ambiguity or dispute down the road. Along the same lines as this, in creating a fully complete contract, is to make sure that you are using all relevant riders and addenda that may apply to your transaction. Those addenda have been created by the committee for a very specific reason. And if a seller financing or a post-occupancy, post-closing occupancy sort of situation is relevant to your transaction, those addenda need to be utilized and filled out completely. So that's kind of a bonus mistake that I'm providing you here, is not using the addenda that apply to your transaction. So this one seems very basic and simple, but I see it all the time. Make sure that the information in the contract is accurate, make sure the contract is completely filled out, and make sure that you're using all addenda that may be relevant to your transaction. Okay, moving on to mistake number 4. And mistakes number 4 and 5 kind of is why I think as real estate agents, you have a very tough job and you're put in a very tough position. So mistake number 4 is failing to advise your client of the importance of signing a legal contract. Again, this may sound extremely basic, but there are many disputes and lawsuits that arise because the parties quite simply had no idea what they were signing. They either didn't read it, or they read it and they didn't understand it and they signed it anyway. And unfortunately, with electronic signing capabilities like DocuSign and things like that, people are able to click through very quickly and sign and don't take the time to read the contract in its entirety, ask questions if they have them, and make sure that they understand their obligations in the contract, their deadlines in the contract, and the consequences of not meeting those obligations and deadlines. That is extremely important to point out to your client. That being said, and I'm going to go ahead and jump into mistake number 5 is giving legal advice to your clients. So on the one hand, yes, you need to make sure you are communicating to your clients that this is a legal binding document. Unless there are specific provisions in the contract which allow you to cancel, once you sign it, you are bound. There is no changing your mind. There's no saying I didn't mean to sign it, or I don't want to do this anymore. You are bound to the contract once you sign it. You need to read the contract in its entirety, and you need to understand it. If you don't understand it, ask me. If I am not able to give you the answers, then I will put you in contact with somebody who can, but you cannot sign this contract unless and until you've read every single word and you understand what you're signing. Now, jumping into the fine line that may be crossed sometimes into giving legal advice. I actually have a full presentation on that one topic, but here is the broad overview or takeaway on that. As licensed real estate agents, what you are allowed to do, which non-licensed lay people cannot, is you are allowed to have a discussion with your client, and you are allowed to take the information the client is telling you and transfer that information into the contract. So if your client is telling you, I want to offer $200,000 and I want to close on this date, you are allowed to gather that information and put it into a standard contract that has been approved by lawyers. FAR contracts, CRISP contracts fall into that category. What you are not allowed to do when it comes to drafting is you are not allowed to draft your own language or language that you come up with that is not standardized unless you're a licensed attorney. So on the contract at the end where it has a paragraph for additional terms, you are not allowed to start typing into that section unless you are typing verbatim what your client is telling you, or you either have an attorney draft that language or you draft it and an attorney reviews and approves that language. Same thing with addenda. You cannot take a blank form addenda and start typing away in it all of these different amendments or contract terms. That is something that must be at a minimum reviewed by an attorney. That is why we have so many standard addenda, and I realize the standard addenda don't cover every single situation. So you are in a very tough position because with the speed of how quickly these transactions are moving, the pressure on you, especially in this market, if you're representing buyers, can be difficult. Nobody wants to call a lawyer and pay for a lawyer review of contracts and things like that. But that would prevent a lot of the disputes that I am seeing. And as agents, to protect yourself, you need to be at least recommending that your client do that. So if your client is saying, what happens if I default on the contract? What's the worst that can happen to me? You cannot advise the client on how the contract works as far as consequences of breach of that contract. You can read the contract to your client. You can put into your own words what the contract says for your client, but you cannot advise of what will happen if this, or what will happen if that. You can't advise of the consequences. That is legal advice. So my recommendation as far as a best practice for all agents is to, in writing, probably by email or even a text message, say, I'm happy to go through the contract with you, but to the extent you have questions that I can't answer, I suggest you contact an attorney to review the contract with you and make sure that you understand everything that's in it and any consequences that may arise out of your failure to perform under the contract. 9 times out of 10, they're not going to take your advice and they're not going to call an attorney to have it reviewed. But that is a decision that they are making, and that is not anything that can be attributed to you or anything that they can come back on and say, well, you didn't tell me, I didn't know. So those are my top 5 mistakes that I see realtors making when filling out and preparing the FAR contract. Number 1, not paying attention to the time for acceptance deadline. Number 2, using an on or before closing date. Number 3, not checking the boxes. Number 4, failing to advise clients on the importance of signing a legal contract. And number 5, giving legal advice. I have a question in the chat here from Bill. I'll go ahead and address that, but in the meantime, I will formally open this up for questions and answers. So if you feel comfortable unmuting yourself and asking me, or if you want to put your questions in the chat, I'll go through and make sure to address all of those. So Bill is asking, is explaining the language in a paragraph of the contract considered legal advice? Probably not. So what you are allowed to do is you are allowed to read the contract terms, and you are allowed to put that language in your own words. Where you cross that line of giving legal advice is when you are adding things to the conversation that are not in the contract. So the inspection period is, the deadline for your inspection period is 15 days after the effective date. The effective date is this, so that means your deadline for the inspection period is that. You are totally fine explaining it in that way. What you can't do is say, if you miss the inspection period and then you still try to cancel, they can sue you for your deposit and damages and specific performance, and they can get their attorney's fees. You can't go into all of that, but you can explain in your own words what the contract is stating. Hopefully that answers your question. Dan asks, will we have access to the recording of this meeting? Great question. And the answer is yes. We are recording this. We post all of our recorded content on our YouTube channel, Martinez Law. And so if you go over to YouTube, you'll see all of our Get Real episodes, as well as my Legal Lounge episodes, and any other video content that we record and produce is posted there on YouTube for you to reference back to. Kelly asks, what about executed/effective date? If the contract is signed October 4th, but the attachments or addendums aren't signed until October 5th, what is the effective date? So as far as effective date goes, the effective date is the date that the last party to the contract signs the contract and it is delivered to the other party. When we are talking about attachments or addenda, if those addenda are part of the contract when it is first presented, everything needs to be signed before we have an effective date. If those addenda are agreed to after the signing of the original contract, then that wouldn't affect the effective date. So I think the question is we're presented with an offer that includes the base contract and 3 addenda. And the seller accepts and signs the base contract, but doesn't sign the addenda until a couple days later. When is the effective date? The effective date is when the seller signs the last of those 3 addenda. That would start your effective date. I don't think that's what most people are doing, but legally that's how it would be. That's how it would be interpreted. Carlos says, love your TikToks. Thank you. We are recently on TikTok as well. And so if you want to be entertained, head over to TikTok. Also, we do post some very informational videos, and I do my best to answer all of the questions on there. A lot of information on land trusts and asset protection and things like that. Those videos are on TikTok. They are not reposted to our YouTube, so you should check out our TikTok as well. Okay, what other questions do you all have for me?
I have a question. First of all, thanks. Thank you so much for providing these. I find them so valuable. And I'm glad to know that you have a YouTube channel, because I'll definitely be sure to check it out. My question is on the effective date. What if you fail to deliver the signed copy to all parties within the 24 hours? How does that affect the effective date?
So effective date is technically on signing and delivery of the contract. That does lead to a lot of confusion about when the actual effective date is. But hopefully you are delivering the contract in a way that can be verified, like in an email or something like that. And so the effective date technically is not going to start until delivery is accomplished. It makes it a lot easier if signing and delivery is on the same day, but if not, the delivery date is going to control on that.
Thank you.
You're welcome. Other questions?
Hey, Kristen, I have a quick question.
Sure.
So going back to this effective date. So if you have a contracted deal that has moved forward, it's been going smoothly, and then we had an issue with an appraisal gap. And so instead of changing the purchase price, we decided to give a credit at close for $2,500. We put that in an addenda to the contract. So does that mean that now the effective date of the contract actually pushes back? I mean, we're supposed to close in less than a week. So that the effective date, so that's going to start all over. So they have another 30 days
No, so the only time an addendum is going to affect the effective date is if that addendum is presented for signing at the same time as the main contract.
Oh,
If
okay.
it is an addendum that occurs after the fact, that is an amendment to the contract that is not going to affect the effective date.
Okay, perfect. Phew, thank you.
That would not be good.
No, thanks.
Absolutely.
Kristen, I have a
it's Bill
question.
again.
Sure.
Go ahead, Bill.
You go ahead.
Okay. So we get a lot of variations of language for appraisal gaps. What's the best advice to give to the customer as to what the appropriate, I get 12 offers on a listing over the weekend, and they've 5 different variations of appraisal gaps that I know are not being written by your office or another attorney.
So what I would recommend, since this situation is so common in the market that we have right now, is to, and I do this for brokerages, but is to create your own standard addendum for whatever situations that you see arising over and over again, and have an attorney review that language as a template, so that way you can just use it over and over again. Without seeing the different variations that you're
Right.
receiving, I can't tell you that, but you want to make sure that the language is as specific as possible, and that there is only one interpretation, one possible interpretation of that language. If you can interpret it in 2 different ways, it's not specific enough, and it may lead to a dispute. So I would either have it reviewed, or I would have your own template, and that way, as you receive offers as part of your counter, you can use the same substantive terms, but just put it in your template and respond with that as a counter offer, even if you are accepting the underlying terms.
Okay, thank you.
Absolutely.
Hey, Kristen, it's Bill.
Hello, Bill. How are you?
Good. Thank you for doing this. As always, you're terrific.
Absolutely. Thank you.
One of the main questions that I get when I'm filling out a contract with the buyer is they're always concerned about their risk of losing their escrow. And of course, there's several places in the contract that could cause them to lose the escrow. In the past, I have gone through great detail in explaining to the buyers what could cause them to lose their escrow. Is that considered me being practicing law if I explain it in such detail? Because they're really concerned about losing $5,000, $10,000, $15,000, if they can't afford that. So, and now in this new contract coming out in November, there's even more places that they can lose their escrow as being defined in there. So it really concerns me. What are your thoughts on that?
So when you are advising clients on this topic, your advice needs to track as closely as possible the language in the contract. So the contract says, if the buyer cancels within the 15-day inspection period, they can terminate and get their deposit back. You can tell them that. Conversely, you can tell them, if you cancel outside of the 15-day inspection period, not talking about financing contingency right now, and I wouldn't talk indefinites as well. So I would say you risk losing your escrow. I wouldn't say you are going to lose it or you are not, because there are so many different factors and legalities that could be argued. I mean, I don't even advise clients like, you're definitely going to get your escrow back if we fight this, because there's so many. We could say, oh, look, the contract was signed after the acceptance date, so there is no contract. And so, I mean, there's so many things that could come up. So my advice would be to stick as closely as you can to the contract language, and do not speak in definite terms when you can. So if they are belaboring the point and kind of asking more and more detailed follow-up questions, at that point, I would advise them and just say, look, I'm not a lawyer. I'm not allowed to advise you on these things. I would recommend that you contact a lawyer, but unfortunately, I risk my license if I advise you specifically on these things. This is my understanding of the contract, but if you need more information than that, I would recommend you speak with a lawyer. And I know that's not probably what your client wants to hear or what you want to tell your client, but to protect you, and I have seen a big rise in litigation in this market that we're in. People are a lot more litigious. So to protect yourselves, that's what I would recommend.
Yeah, there's a lot more risk involved in for the buyer in losing that escrow. And especially nowadays when offers are going in one after another on a daily basis, and the buyers can't even find a property to win on. So, and they want to sign their contract immediately.
Whoops, sorry about that. Yes, exactly. And so that's why I say, you know, you guys have such a hard job, because it is moving very quickly. Okay, I need to talk to a lawyer. Well, I call the lawyer and they can't see me until next week, and I got to make my offer before next week. And so I do understand. But at a minimum, I would recommend that you make that suggestion to them, and then they can decide, is it more important that I get my offer in quickly, or is it more important that I fully understand? And there's not a right or wrong answer to that. That's a choice that they can make for themselves.
Thank you.
Absolutely. Any other questions? Let me check the chat. I think we have a few more minutes for some additional questions if you have them. While we have a little pause here, speaking of the new revisions to the contract, that is going to be our topic for November's Get Real. So there are many, many, many revisions, if you've seen the red line version, to the contract that does become effective November 1st. So I won't be able to go through all of them, but there are some changes that are more substantive than others. So I'm going to hit on the main ones and what you need to look out for. You know, calculation of time, financing, those all have some pretty significant changes, appraisal contingencies, things like that. So that will be our topic for next month's Get Real. I hope you will join me for that. And if you all have any questions, I'm happy to address them now. Let me make sure. All right. Well, if we don't have any other questions,
Hey, Cristen.
Yes, ma'am.
Cristen, this is really a pet peeve of mine. I'm seeing a lot of agents submitting offers. You know how on the first page it talks about, and I don't know if people really care, but I do. In the first page where you write in the price and then the deposit and then the financing and then the balance to close. And I see so many agents not filling in any of those, well, not filling in complete information. Like, for example, there is financing, but yet they don't put financing in the front and then put balance to close as the full balance or less whatever the escrow deposit. And then on then of course I think, oh, this may be cash. And then I go to the second page and then they check the box for financing, which I see a lot like that. And how important it is, because I do go back to the agent and said, well, if this is being financed, you need to do this. But I feel like I'm always correcting. So how important is that?
That is very important. And that is one of the areas that I do often see that is either not filled out completely or not filled out accurately. So again, I mean, the whole purpose of a contract is to get the entire agreement of the parties in writing, make sure all parties are on the same page, and to reduce any sort of ambiguity that we can possibly reduce to avoid dispute down the road. And so I would absolutely request and require that that be corrected or filled in, or I would fill it in yourself as part of a counter offer for the buyer to initial off on. But if there are conflicting terms, like it appears to be cash in paragraph 2, but in paragraph 8, I think it is, for financing, they're marking that there's a financing contingency, that is a recipe for potential dispute, ambiguity, those sorts of things. So I think it is your duty to your client to make sure that you are responding and making sure that that is filled out and that it's filled out properly.
Yeah,
Hey, Cristen,
thanks.
along those lines, we get an offer and there's spots left vacant. So if we're sending it back marked, everybody would need to then initial. Is that correct? Even if it says, if it's left blank, But now if I'm doing the diligence and marking the box or having to make sure the seller's okay with having the box marked, now the buyers would then, and sellers would need to initial on any of those changes, correct? Just for clarity.
Correct. So if anything is different in what you're sending back from what was originally sent to you,
Right.
it needs an initial, even if you are filling in the default date. So if left blank 15 days and you're filling in 15 days, it would still need to be initial.
Perfect, thanks.
All right, any other questions? All right, well, what I will do is, Jennifer, if you could put my email address in the chat before we wrap up here. If you think of any other questions or you have questions for me, let me know. I'm always looking for content for videos and social media and things like that. And I want to talk about what you guys are seeing in the market and are giving you issues and what you're experiencing. So all of that sort of feedback, all of those questions are definitely appreciated. If there are no more questions, Jen, if you want to go ahead and wrap up, thank you all for attending. I love doing these. This is one of the favorite parts of my job that I have, is getting to interact with the community and provide these educational forums for you. So thank you all for attending. And Jen, do you want to go ahead and wrap up?
Yes. All right. Thank you all so much for attending today's Get Real with Attorney Martinez. As a reminder, they are held the first Wednesday of each month. This month we did it via Zoom. Next month we look forward to inviting you to our newly located in Hillsborough County office. So stay tuned for the address for that. The topic again will be revisions to the FAR bar contract. And that again is the first Wednesday of each month. So feel free to invite anyone you feel could benefit from this presentation. And if you have any questions, Kristen's email address is in the chat box, and this video will be available via YouTube. So thank you again and have a great rest of your week.
Thank you all.
Bye.
Thank you.
Thank you.